All right, drivers, well, welcome back to Inside Trucking. This is James Lamb. I'm your host. This is episode 13 of Inside Trucking called Stay Just a Little Bit Longer. All right, so welcome back, truckers. And, when I say welcome back, truckers, most of the viewers, we presume are truckers. But there's a lot of other transportation professionals that, we see are watching and even members of the general public, that want to just know what's going on inside trucking. So welcome to everyone who's tuning in on this Sunday afternoon. Today is November 16th, 2025. And boy, do we have a lot to tell you about today in terms of what's happened over the past week since we did our last version or episode of Inside Trucking. So let me kind of just cut to the chase here and let's get into it. So there were two major events that happened, and they came in the form of trucking lawsuit or trucking litigation related decisions from the court. And it's really not really about trucking companies getting sued, right? It's about the Secretary of Transportation and FMCSA getting sued. And what I should start off by saying is that this is very confusing, and it's even confusing to some of the lawyers that I talk to. And before I go there, let me just say I am not a lawyer. And although I am the executive director of the Small Business and Transportation Coalition that has a legal team, many different lawyers for different things, trademarks and, general legal advice and the like. And we have consulted with, one of our attorneys on what I'm about to tell you. I'm not an attorney, and you should not deem this as legal advice. Okay. So with that said, I draw on what our attorneys say and quite frankly, my own personal experience as a litigant, whether on behalf of SBTC or personally in federal court, state court, the full gamut I've done. So, I've been around the block a few times, so I know a thing or two, as they say on that insurance commercial. So let me start by saying that at about the same time in October, there were two federal lawsuits that were filed against essentially USDOT. One came against Secretary Duffy, and the other one came against the operating administration, FMCSA, within USDOT. But for all intents and purposes, these are two almost identical lawsuits against USDOT. And they have to do with the Interim Final Rule that came out on September 29th of 2025 to address the problem of illegal immigrants unlawfully getting CDLs, right? So this was Secretary Duffy and his team, including eventually Derek Bars and Jesse Elison and all those folks. This was basically them trying to fix a problem, and it's a serious problem that we have all come to really fully appreciate over the last 90 to 120 days, going back to mid-August, right, with that Florida U-turn fatality by an illegal immigrant. Let's talk about that. We're not against immigrants. In fact, my own daughter's mother is a immigrant. She's a legal immigrant, right? So, the point here is that this is about illegal immigrants. This is about people who come here and they invade the country basically through those open borders from the Biden administration. And then the states have some kind of woke mentality where they give people who don't qualify for licenses because of their lack of legal immigration status or the fact that, they don't speak English proficiently and they just let them have licenses when they shouldn't. So this was Secretary Duffy really cracking down. And we had asked, for this type of crackdown way back in 2022 to the Biden administration, to Secretary Pete. And those guys weren't having anything, to do with anything that we had proposed, like them following their own rules. So, so here we have a different administration. We have a reasonable and rational and logical administration that says, hey, we should probably enforce our own rules. So that's what this is all about, right? And it started with English language proficiency, and it developed into not only do some of these guys not speak English, but hey, you know, some of them are not even legal to be here, and how do they get CDLs, you know, to begin with? And how do we find out about these people? Usually it's at the scene of a fatality, when 3 people are killed in Florida by an illegal immigrant who doesn't speak English. And then, you know, another person, you know, in, I think it was Indiana, and that guy didn't even have a CDL and didn't speak English. And how did he get operating authority from USDOT, which he has, you know? And then, you know, again, another guy by the same name, Singh, you know, in California, a younger guy, and he's an illegal immigrant, also from India, just like the one in Florida in August. So, you know, this was a crackdown, and this was an emergency crackdown. And so what happened here is there were 2 lawsuits that were filed, and they're only filed 3 days apart, right? So the first one is the one that I think is the main one on everybody's radar, and it's the one that's filed by this, you know, public interest group called Public Citizen, right, on behalf of this one driver named Jorge Lujan, and 2 unions, which have to do with teachers unions and municipal workers unions, and it's not clear, you know, other than, you know, who's going to drive the school buses, you know, it's unclear, and do you really want an illegal immigrant who we don't know whether they're really qualified or not to drive, you know, is the, you know, the footnote to that. So, you know, this is about, you know, some strange, you know, plaintiff, I guess you would say, you know, that is filing this lawsuit. And so let's distinguish the 2 here, right? So the first one I've mentioned is Jorge Lujan versus Jorge Lujan et al., right, because it's these other 2 unions, versus FMCSA, but it's entitled Jorge Lujan v. FMCSA, and it's filed on October 20th. And the case number is 25-1215, in case you want to go look that up on the internet. And then the other one is Martin Luther King Jr. County. I'm not sure what state that county is in, but it's a county government versus Sean Duffy in his capacity as the Secretary of Transportation. That's filed 3 days later on October 23rd. And that case is case number 25-1224. Now, let me explain here that there's like a law, you know, that basically has to do with how you sue FMCSA. And in most instances, when you're trying to get the court system to engage in judicial review of a particular regulation, you don't go to a federal district judge. You don't go to one judge. You go to the Court of Appeals directly. It's like a fast track, right? So when we're talking about this appeals, these 2 appeals cases, there weren't any, like, you know, original trial court cases, and now it's being appealed. This is these petitioners going directly to the U.S. Court of Appeals for the D.C. Circuit, where the government is based. So that's, you know, point number 1. And then point number 2 is, because these cases are interrelated and they're both challenging that September 29th, 2025 FMCSA emergency rulemaking regarding illegal immigrants getting CDLs, what they call the IFR, the Interim Final Rule, which it's final, yet there's still like a comment period associated with it, which is, you know, interesting. But, you know, it's final in the context of it takes effect immediately, you know, as of the date that it is published in the Federal Register, which came out, like I said, on September 29th of 2025. So, so what's happened here is, because there's 2 cases, the court, they're both in, you know, in the same court, DC Circuit. So the court has consolidated these 2 cases. So it's basically now one, with these 2 separate, you know, sets of petitioners suing USDOT. So it's all considered one case now, right? So what's happened over the last week since I last saw you all, on Monday, November 10th, the court ordered what's called an administrative stay on the IFR, right, Interim Final Rule, pending review. Okay, so the whole thing is considered a review. It's the whole case, right? The case is a petition for review by the U.S. Court of Appeals. So that's what pending review means. It means adjudication of the whole case. Now, what's important for you to understand is that the U.S. Court of Appeals for each of these, circuits, in this case the D.C. Circuit, they operate in two capacities. One is what's called a panel, and that's usually 3 judges, that hear a case and make decisions. And then there's the full U.S. Court of Appeals, right, which can be like a dozen or more judges. And when you're in front of the full court, it's called en banc, E-N-B-A-N-C, en banc. And so here, this is not the full court, right? This is just 3 judges. And so when the 3 judges met and they decided on this administrative stay, and by the way, this is all framed in the context of, oh my God, this is an emergency. Judges, you need to rule on this right now, right? These are all like emergency measures. So the court decided to issue the administrative stay pending review, and it's 2 different interpretations of pending review. So I think in this case they meant pending review until we can actually get to review your emergency stay. So it's very, very confusing, right? So in my experience, I haven't never seen anything like this, and I've been around the block a few times, so usually the way this works is you go to a judge, and most of the time, you're doing this what I forget the term, but it's ex parte, right? It's when you're talking privately, just you as a party and the judge, and the other party's not involved, right? And you say, Judge, there's something going on here, and we need an emergency temporary restraining order against the other side. And so the other side doesn't know about this. They don't get to, hear about it until after it's, decided on. And the judge on the spot makes a decision and says, okay, emergency, restraining order is currently in effect. Go ahead and serve it on the other party. And then 10 days later, we're going to have a hearing on the issue. And then I will, decide as a matter of temporary orders whether to convert that, temporary restraining order into a temporary or preliminary injunction, right? And then that is in place for the course of the whole case until the ending of the case. And then either, the side that won, that asked for and got the temporary, preliminary order, that gets converted usually into a permanent injunction, or if they lose, the whole thing, is then dissolved. So what happened here is that there was an emergency, filing, an emergency motion to the U.S. Court of Appeals, the 3 judges, and so they acted on that on Monday, and they gave an emergency administrative stay until they could take the next 3 days to decide what they should do about that decision on Monday. On Thursday, they decided, whether we should now, after having had a chance to think about it for a few days, whether we should make that the, preliminary stay pending the resolution of the case that would move forward. So that's apparently what they did. So in other words, it looks like there was 2 emergency stays, right? So by a vote of 2-1, so this is not a consensus, by any means. This is just, the majority 2 against 1 decided on Monday to issue that administrative stay on the IFR pending, review. And then 3 days later, on Thursday, that administrative stay was dissolved by this 3-panel appeals court, again by 2-1, and they then replaced it with this emergency motion for stay that they granted, right? So for whatever reason, they needed to make a decision immediately and then, take 3 days to make another decision on an emergency motion. So totally confusing. And if you don't understand it, there's some lawyers, I think, that I've talked to that don't fully understand what the heck went on here. But bottom line is that now the Monday stay is gone and the Thursday stay is in full force and effect. And in both instances, I'll name the judges here because, they're public records, so the two judges that voted yes for both stays are Judges Wilkins and Pan, and the one that filed a dissent in both, instances is Judge Henderson. And so this is what's going on. Now, some of the media outlets, including Fox News and Overdrive, Overdrive did a pretty good job about, explaining that there's two things going on here. But like Fox News, really botched it. And if you noticed, I don't know if you picked this up, but I did. When they first, put this on the homepage of foxnews.com, what they did is they said a federal judge has, overruled Secretary Duffy's IFR, right? So first, it wasn't one federal judge, it was a panel of three. And so they corrected that, later in the day. And then two, they haven't overruled him. What they've done is they've basically put a temporary stay in place. What's important is to know that in order to do that, these 2 out of 3 judges had to conclude that the petitioners filing against this IFR have a reasonable likelihood of ultimate success. And so they're saying that, the petitioners have met that standard, and that's why the temporary order, the emergency motion for stay was granted on the basis that they're probably going to win, when we're all said and done. Now, even if that happens, and even if they do, there is an option for the losing party, let's say it's FMCSA. The government has plenty of resources, so there's no reason why, they, through the Attorney General, Department of Justice and all, why they wouldn't pursue this. Trust me, it's hard to fight the U.S. government. It's very expensive, too. I know, firsthand in a number of different capacities. So let's just say that FMCSA loses. That's not going to be the end of this, right? First of all, they have an option of petitioning for en banc review. All 11 judges that are on the D.C. Circuit Court, appeals court, they can say, well, it's nice that 3, considered this. We want 11 to now consider this, right? So that can happen. The other side would object, of course. And then they'd make the decision whether or not they're going to do that. And then if they do, then, 11 judges will be chiming in instead of just 3. That could happen. And then the losing party can try to get review by the U.S. Supreme Court, although that's very, slim. It really has to be an issue that the court is looking to, take up and decide. Or, they can either go, with a petition straight to the Supreme Court, or after en banc, they can do that, right? So, it's just another level of appeal, and then that would be the ultimate decision. There is nothing, of course, as we all know, beyond the U.S. Court of Appeals. So let me get into now, what they did is they combined these two cases. So it's basically just one case now. And it looks like they're doing it under 25-1215, so Jorge's, case. And so what the majority of the 3-judge panel decided on November 13th is that they were granting this emergency motion for stay and dissolving the temporary administrative stay for Monday, and they're doing it pending the court's review of the whole matter. So, any media outlet that's saying this is, all done is just, not understanding that that's not exactly where we are in the process. This is all preliminary stages. This is the part where I reach for my glasses because now I got to read some stuff that I can't otherwise see as I'm getting older. So here we go. So the majority rules and says, they say basically, that the petitioners are likely to succeed in at least 3 of their challenges of the interim final rule, right? And of course, this rule narrowed the circumstances under which states could grant or renew non-domicile commercial driver licenses. So, of those 3 things, here they are. So, number 1, But the court is agreeing with the petitioners, saying that FMCSA improperly issued the rule without prior consultation with the states. And FMCSA, acknowledged that normally is the case, that there should be state consultation, but basically they said it was not practical, and the court rejected that and said, we disagree. The second had to do with the fact that they argued, and the court agreed, that FMCSA has not satisfied what's called the narrow good cause exception to issue a rule without the normal notice and comment procedure, that's required from the Administrative Procedure Act. That's basically due process to promulgate a rule. And so they really delved into the FMCSA's own data. According to that data, non-domiciled CDL holders account for approximately 5% of all CDL holders, but only about 0.2% of fatal crashes, right? This has to do with the statistics for fatal crashes involving large trucks and buses as of September 26th of 2025, year to date, right? So 2,399, right? And then the third thing is that they said, well, the petitioners are likely to succeed on their claim that FMCSA acted arbitrarily and capriciously in issuing the rule. And that has to do with, again, the data that appears to indicate that CDL holders that would be excluded by the rule, and that's like up to 200,000 people who don't really qualify for CDL, are involved in fatal crashes at a lower rate than CDL holders are not excluded. And so this looks like this is, misinterpretation of data, incomplete data, twisting of data. Like, this is all being done very rushed. This is like, hurry up and, respond to these emergency petitions and the like. And so the dissenting judge, will chime in on that. We'll get to that in just a moment. So the majority basically says FMCSA does not appear to have articulated a satisfactory explanation for how the rule would promote safety, and they basically say FMCSA does not appear to have demonstrated any safety benefit from the rule, right? So this is the opinion and perspective of two of the three panel judges on the Court of Appeals for the D.C. Circuit. Now, comes next is the dissenter, the Honorable Karen Henderson, circuit judge, and she says, this is like emergency, drop everything you're doing and look at this and make a decision, kind of stuff that we're dealing with here. And she's saying, should we be doing this in an emergency motion, or should we, go through the full course and then, issue a well thought out, well researched final, decision. And so she says, granting the extraordinary remedy of a stay rather than expediting our review of the merits is particularly inappropriate here. So she's saying, there could be an emergency motion, or we can go through the full case, but there's even a way to elevate this and give it like priority treatment, expedite it, right? And so she's saying, well, we should have done that. And she says, to warrant a stay appeal, or she says to warrant a stay pending appeal, the movant, which is the petitioners in this instance, Public Citizen et al., must make a strong showing that he is likely to succeed on the merits, that he will be irreparably harmed absent a stay, and that the balance of equities favors relief, and that a stay is in the public interest. And so she goes on to say the petitioners are unlikely to succeed on their claim that FMCSA lacked good cause to issue its IFR without notice and comment. The APA permits agencies to bypass ordinary notice and comment procedures if, quote, the agency for good cause finds, end quote, such procedures, quote, impracticable, unnecessary, or contrary to the public interest, end quote. So she basically says, listen, this was like an agency judgment call. And, in this new era of, Chevron being dead and you don't have to defer to agencies anymore, we might want to really tread lightly on that, because, there's times when the court should take over. And then there's times when, the court still might want to defer to an agency's judgment, because they have technical, knowledge and expertise that the court simply doesn't have. They're the experts on, transportation regulations, and then the courts are, above them, but, they don't have that expertise necessarily. And for them to get up to speed in a matter of, just a few days to make this determination, is that's a stretch in my book. The dissenter then says the FMCSA invoked the good cause exception based on a determination that advance notice and comment would likely cause a concentrated surge of CDL applications in which large numbers of drivers ineligible under the new rule would apply for and obtain CDL licenses before that rule went into effect, if they did do public notice and comment. So in other words, this was like, we don't want more people sneaking in at the 11th hour. We want to stop this and stop it altogether right now. And that was the reason why they did this. And so the dissenting Judge Henderson says, our only task then is to determine whether the FMCSA presented sufficient evidence in support of its good cause determination. That's what they're supposed to be doing here, not second guessing the agency, the way it's been done. She says, as far as arbitrary and capricious, the FMCSA articulated two independent justifications for its rule, both of which bear a rational connection between the facts found and the choice made. And she cites another court case with respect to that called Sorensen v. FCC, which you can look up. And then she says the FMCSA's implementing regulations require the states to complete a check of an applicant's driving record before issuing the applicant a CDL. She says what FMCSA is trying to do here is close a loophole that has been in existence that brings into question public safety. And so in other words, if a state is issuing a CDL, they're supposed to check with the previous state and find out what the record is before they make a decision on granting the CDL. And you can't do that with Mr. Singh or Mr. Singh if their previous record is not with a state, but is with a foreign government regulatory agency. So how do you issue a CDL to these guys when you can't check to make sure that they're safe, like the regulations say that you're supposed to do? So, that's what FMCSA is articulating, and this judge says that, that's legitimate. We should not be putting questionably unsafe drivers or questionable drivers who may be unsafe, and there may be a record somewhere in the world of them being unsafe. They could have gotten many violations. They could have had a lot of accidents. They could have killed people, let's say in India, So how do we issue a license if we can't do that? So that's part of all this. And then she says basically that when it comes to these 5 fatal crashes that FMCSA offered in the rule and to the court is acting like it's only 5 fatalities this year, and it's only 12 people who are dead. Now, it's at least 14 or 15, depending on where they left off with this. If you look at the Singh fatality in California, I counted 14 at least this year. But, it was 12 at the time of this filing, apparently. And so this dissenting judge is saying, listen, they didn't say that there were only 5 crashes, by illegal immigrants, and only 12 people died this year. They were just giving that as an example. And so it's more along the lines of it's at least 5 fatal crashes. So the dissenting judge says that FMCSA's determination was reasonable, and that allowing CDL holders with unverified driving histories on our roadways is simply unsafe. And in any event, it was well within the agency's policy judgment, authority to determine that 5 fatal crashes, which claimed the lives of 12 individuals, 2 of whom were children, this judge notes, were 5 crashes too many. And doesn't that kind of say it all, folks? This judge said, we should really have resolved these issues on an expedited merit review rather than rush to judgment and jump to, conclusions and basically issue this, emergency stay. Now, the issue of data has come up. And, the other day I saw there's Ken Adamo from DAT Freight and Analytics, and he's chiming in. And, he goes and he starts to read this case and tweet to about Secretary Duffy and, FMCSA, you guys don't know what you're doing with your own data. And, he's criticizing them like big time. Meanwhile, he's the guy that we believe has been manipulating data, right? He's the guy who says, brokers on average have 12.5% margins, right? And getting him to define margins, whether they're gross margins or net profit margins, that's been like 2 years in the works. And so, that's a difficult one, especially since he cut off all communications with us because he doesn't want to be put on the spot, apparently, and answer questions that, industry has. So 12.5%, he says, and then, TIA put out something 5 years ago saying it's 16%. Looks like DAT is on the board of directors for TIA in terms of like an ex officio director circle capacity. So they're all, collaborating, as Boltman used to say. And, ultimately, one has to question, where does this 40%, what we call commission, come out when it comes to the Pink Cheetah case, right? From the infamous load of ice cream 2023, right? That doesn't seem to fit in between 12.5% and 16%, right? Whether you listen to Ken Adamo, 12.5% in 2025, or Bob Voltman, 16% in 2020, 40% is nowhere near that, right? And it clearly was 40% based on the documents we reviewed that we got from FMCSA on a FOIA request. So, here's this guy chiming and telling Secretary of Transportation, you don't know what you're doing, right? I think some people need to tell him that he does know what he's doing, and it's not good what he's doing. But we'll get back to that another time. So what's important to talk about is the nature of these data, and everybody's rushing, with these filings that nobody has a moment to stop and think and really put together, a cohesive argument. That's why SBTC is going to chime in on this case, and we have voted. The board has voted to file an amicus or amicus, depending on how you want to say it, friend of the court brief to kind of insert our 2 cents into the equation. And what we are going to do is what we did in the first episode of Inside Trucking, and basically that is to talk about where this all started. And this started with drivers who do not speak English, right? It goes back to 2022, all those 4 different actions we took as SBTC trying to get the federal government at the time to enforce their own ELP, regulations. And by the way, don't forget that we are hosting or sponsoring a webinar on ELP assessments, because Duffy is coming after trucking companies. He has told us he wants to go after brokers and even shippers. He's tweeting about it. So we have put together on Tuesday, the 18th, we have put together a webinar with our partners LTI, Language Testing International, and it will be at noon. So what you're going to want to do is you're going to want to go to truckers.com or smalltransportation.org right after you finish watching this, and click on that registration link. and you will be able to, to go and watch that if you're an SBTC member. And if you're not an SBTC member, you can join the SBTC and qualify to attend the webinar, through smalltransportation.org as well. So we encourage you to do that. We encourage you to sign up because it will help you understand as a carrier how you can mitigate what's coming down the pike next, which is an all-out assault on trucking companies that are putting drivers behind the wheel that are not qualified by virtue of not being able to speak English proficiently. So these folks will help you get into compliance, and if you're not, and help you stay in compliance if you are, so that you have this tool of language assessments under your belt. So don't miss that. Coming up Tuesday at noon Eastern Time, LTI webinar. Visit smalltransportation.org, sponsored by SBTC for SBTC members, and you can find out more on Tuesday. But getting back to the first episode of Inside Trucking, which had followed, like within moments, my appearance on Newsmax, Saturday Agenda with Rob Astorino. In both episodes, I made it clear what's happened over the last few years. And I think this is something that needs to go before the court, and SBTC is going to put it in front of the court. And this comes from data of USDOT, National Highway Traffic Safety Administration data, NHTSA. And it has to do with what's happened over the last 12 years or so, meaning 2013 up until the most recent published data of 2023. Hope you're paying attention, Ken, because this is how you handle data, right? And we noticed in comparison that in 2013 there were 73,000 large truck accidents where there was an injury, a recordable accident, personal injury. And of those, there were 3,921 large truck fatalities, and of those, 3,286, the fatality was other than the driver, right? So some of them were the driver died, and most of the time, the accident resulted in someone other than the truck driver dying. So 73,000 overall, 3,921 total large truck fatalities for that year in 2013, and 3,286 were non-truck occupants, right? Fast forward to 2023, and there's 114,552 large truck accidents where there's injuries. And of those, 5,375 large truck fatalities, 4,511 other than the driver. So when we look at the percentage of change from 2013 to 2023, it's an increase of 57% accidents with injuries overall, 37% either way, whether it's the occupant of the truck or not, in terms of large truck fatalities. Now, what happened during this time period? Well, in 2015, CVSA decided to remove ELP violations from their out-of-service criteria. And in 2016, during the Obama administration, towards the end, FMCSA said, yep, that's fine with us. You can do that. And they issued that stand-down memorandum that basically told their own employees, don't put people out of service. And it had to do with civil rights and all sorts of stuff, right? And so basically don't enforce our own regulations as to what qualifies someone to drive a truck. And if you find them unqualified in violation of the regulations, our own regulations, and, you don't know what to do, just give them a ticket and then let them go on their way and continue to be an unqualified driver on America's public highways, right? That's what they did. And so that's from, let's say, 2016 to 2023. Well, look what happened. Now we talk about open borders during the Biden administration during that time period as well, right? And what happened? It's a 37% increase from 13 to 23, but it's a 34% increase from 2015 up until 2023. And so that's more than a third increase in deaths. Now, extrapolation, we are, saying, that this is not necessarily causation, but it seems to be a correlation, right? You know those terms, Ken, right? Causation versus correlation, right? I took SPSS, stats in grad school too, pal, So I know all about, what's statistically significant and all that kind of stuff, right? And so the bottom line is that there's reason to believe that this can be attributed to an influx of illegal truckers, many of whom did not speak English, and others who are American citizens that don't speak English, who really were supposed to be tested, according to the Inspector General from 2002, right? From their CDL standards report, they're supposed to be tested by the states, and FMCSA doesn't make them test, right? So that's why you see Connor's Law, and you see, all these different bills popping up because of this problem that this IFR was trying to resolve as a timeout. And what's really interesting is if you think about it, here's the court doing an emergency stay, right, as a timeout, right? Let's put the rule in timeout. But what the rule did was it put the states in timeout until we could figure out through notice and comment period that we're doing it anyway, what's going on here and how we should handle this moving forward. So it's okay for the court to do a timeout, but it's not okay for the secretary to do a timeout. That's the lesson, that we're learning from this. So we don't know what's going to happen next. We do know that we're going to file an amicus brief within the next week as this case proceeds. But that's what's going on, and this is not any final decision by any means. This is not one judge that's acting. This is going to be an ongoing thing for a while. So with that said, I'm James Lamb, and thank you for watching Inside Trucking, and we hope that you'll come back and that you'll stay just a little bit longer. Thanks for watching, everybody, and we'll see you next time, and keep working to make the road safe again. Thanks.